Oh, yay, oh, yay, oh, yay. This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning and welcome to this session of the Tennessee Supreme Court with our Knoxville docket. We are continuing our efforts during the pandemic to be able to hear our cases and move forward in our justice system in Tennessee. As a part of that, we're doing our oral arguments by Zoom today with live streaming on YouTube. We welcome the lawyers. Appreciate you very much for agreeing to be with us today by Zoom, and we welcome those of you that are watching on YouTube, the live stream feed. In just a few moments, we'll get started here with each case. We again appreciate the lawyers doing this. We recognize it's a little different, but I think we're all getting a little more used to it every time that we're doing this. But it is the way that we are continuing to operate during this time. In just a moment, Mr. Hivner will call our first case. When that happens, each side will have 30 minutes for argument. If the appellate wishes to reserve any time for rebuttal, please let us know at the beginning of your argument. With that being said, I think we're ready to begin. Mr. Hivner, will you call our first case, please?
Jared Effler et al. Versus Purdue Pharma LP et al.
May it please the court, I'm Anthony Franz. I represent defendants Endo Pharmaceuticals, Inc. and Endo's Health Solution, Inc. I'll be arguing today for all the manufacturer defendants. I'd like to reserve 10 minutes for rebuttal, please.
All right, thank you, Mr. Franz. As you can see, the clock is up, so you can tell how much time is remaining.
The Court of Appeals decision should be reversed for two reasons. First, the district attorney plaintiffs lack statutory standing to bring this lawsuit under the Drug Dealer Liability Act. And second, the Ddla does not apply to the alleged conduct here. On the first issue, the Court of Appeals erred in holding that the Ddla empowers local criminal prosecutors to unilaterally bring Ddla civil lawsuits on behalf of political subdivisions. The statute's clear text establishes that DAs can't do this. Section 106 of the Ddla specifies the parties who, quote, may bring an action for damages, end quote. Under the Act, Section 106 lists 5 specific categories of persons with standing to sue. District attorneys aren't on the list. And under the plain language and settled laws of statutory interpretation, that should end the matter. Even the state.
Let me ask you this question. If it had been reversed, where suit was filed by Campbell County, City of Jellicoe, City of La Follette, et cetera, by Mr. Effler as in his official capacity as District Attorney General, would standing be an issue if it had been sort of flip-flopped there in terms of the party and the attorney?
Yeah, standing would still be an issue because official capacity suits still require the authorization of the legislature. A public official cannot just on its own file a lawsuit and just designate it as an official capacity suit. So the same issue would be present here.
Even if, say, Campbell County authorized Mr. Effler to bring the suit, well, as its attorney, would that work under this statute? If
the county had hired the district attorneys to serve as counsel, then yes, our position is that the Drug Dealer Liability Act authorizes DAs to serve as legal counsel. But that's not what they're alleging here. They're alleging that they are the party plaintiff and that they have the unilateral right to bring the action, even if they're not authorized to sue.
Is there any evidence that Campbell County, City of Jellicoe, et cetera, all these listed municipalities, governmental entities, passed resolutions authorizing these district attorney generals to bring this case for them?
No, and the record does not show any authorization to bring these suits, and authorization would have been invalid when the legislature identifies a discrete group of plaintiffs who may bring an action and the wrong party brings that action, this court has held that that's an issue of subject matter jurisdiction. So there, you can't have a party with the standing to sue give someone with no standing to sue authorization.
Mr. Franz, this is Justice Clark. Is it correct procedurally that plaintiffs have now dismissed all of their original claims except the Ddla claims?
Yes.
So there are no more state claims per se in this current lawsuit, are there?
That is correct.
Does that affect your argument in any way?
No, none whatsoever.
Okay.
Mr. Franz, this is Justice Page. Because I know there are two baby doe plaintiffs here and there are other cases pending, similar cases. But my question is, if we agree with you on standing, where does that leave the plaintiffs in this case? What happens to the lawsuit?
If you agree with us on standing, then the district attorney's claims reportedly on behalf of the political subdivision have to be dismissed for lack of subject matter jurisdiction. But the claims of the minor plaintiffs would remain because they have standing to sue under Section 106.
Should that matter to us as a policy matter? Because I know we have a statute of limitations problem here for entities to file suit at this time.
Well, what should matter to the court is that the legislature designated who can bring an action and was very specific about it. And it did not include in Section 106 district attorneys. Now, if this action is dismissed and some of these political subdivisions decide to bring their own lawsuits, the trial court is capable of addressing any statute of limitations issues or tolling arguments. If one were to come in and say that we didn't file suit because the district attorneys had brought this action, and the Ddla itself has different tolling provisions, but when it comes to statutory interpretation, the words of the statute should matter and not the potential ramifications down the road. And in the
counsel, this is Justice Kirby. If we were to agree with you, could the correct plaintiffs be substituted?
No, because in the Osborne case, this court said that when the legislature lists who can sue and the wrong person sues, then that's a matter of interwoven with subject matter jurisdiction. And the trial court never had jurisdiction from the outset. The case is a nullity. So there's nothing to go back to in time to substitute parties into the case. And that's not unusual when representative parties are, the wrong person is sued instead of the proper designated representatives.
Mr. Franz, this is Justice Bivens. Is there any prohibition in the Ddla for a class action lawsuit?
I don't believe there is a prohibition in the Ddla for a class action lawsuit.
And this is Justice Clark. Is there any specific authorization? What law would we look to about that?
In the Drug Dealer Liability Act, the authorization to sue is under Section 106, which is clearly the standing provision. And plaintiffs argue that a different provision, Section 116, grants them the authorization. But it is plain that 106 was the provision the legislature intended to cover standing. It used the language of standing. It said, parties, here are the parties who have the right to bring an action for damages, whereas Section 116 used the word to represent. And under this settled law, when the legislature uses different terminologies in the same act and different provisions, that's intended to be purposeful.
Counsel, this is Justice Kirby. Your opposing counsel argues that the term represent in this context can be taken to mean essentially stand in for the other governmental entities. I'd like you to address that argument specifically.
Okay, the word represent, in common usage, the word represent means to represent as counsel, and they don't dispute that.
Actually, the dictionary definition involves several different ones. So tell us why it would not involve this one in this particular case.
When the legislature, when it's speaking of, uses the word represent with respect to district attorneys, and it doesn't use represent to mean stand in the rights of the parties. It uses the term to mean represent as counsel. When the legislature wants the district attorneys to have the right to bring a civil action, it uses words like bring or initiate, and it uses the word represent to mean to serve in a defensive capacity. And the state's amicus state agrees with us on the standing issue here, and their amicus brief lays out the statutes, and the plaintiffs identify no statute where the legislature used the word represent to mean stand in the shoes of. And when the legislature does intend for a party to stand in the shoes of a political subdivision or state, it tends to speak clearly, like in the False Claims Act. In the False Claims Act, the legislature used the words that a person may sue in the name of a political subdivision or in the name of the state. And when the legislature does that, it also does something else that this statute doesn't do, which shows that their interpretation is incorrect. The legislature makes clear what the rights of the represented party are. In the False Claims Act, it makes provisions to determine if the represented party wants to bring its own lawsuit, then the plaintiff in the False Claims Act cannot bring a suit, which avoids these issues we're having in this case with duplicative lawsuits. And in the False Claims Act, it provides various provisions that allow the governmental entities, as you would expect, to have a say in the litigation.
If we were to agree with you, do all the claims in the lawsuit still remain?
If you were to agree with us, then all of the claims of the district attorneys would have to be dismissed because their only claims are under the Ddla. The claims of the minor plaintiffs, while we should be dismissed for other reasons, they shouldn't be dismissed for lack of standing.
Why don't you go? I'm sorry. Go ahead, Justice Lee.
And I think I was going to ask you to proceed to the Ddla claim.
That's what I was going to say as well. So.
To the minor plaintiffs, this is here on a motion to dismiss, and the complaint makes some very strong allegations against the defendants in terms of knowing involvement in marketing drugs that will end up in illegal, to be used illegally. And whether the plaintiffs can prove those, we do not know it. Those claims we do not know at this point, but we have to take all those claims as being true at this point. So assuming all those claims they've made are true, why doesn't the Ddla apply here to these defendants?
Yes, and we are accepting for the sake of this proceeding that they are true, but only they certainly haven't been proven. But for a motion to dismiss, even accepting those allegations is true, the Ddla does not apply to the alleged conduct here. The Drug Dealer Liability Act, as its name suggests, was aimed at targeting drug dealers and their criminal associates in the unregulated, clandestine, illegal drug market. It was never intended to apply to major pharmaceutical companies operating in the separate lawful market for FDA-approved prescription medications. The Ddla was designed as a gap filler to address a unique problem in the common law, the inability of people injured by illegal drug dealers to even be able to identify the members of the illegal drug chain to allow them to sue. For lawful prescription medications, there is no gap that needs to be filled. It is one of the most heavily regulated markets in the country that provides for vast regulatory and criminal enforcement. and their complaint, laid out various enforcement
That
actions.
you have exceeded your registration and you have gone, the drug companies have gone beyond registration and exceeded authority and gone from the legal realm to the illegal based on its marketing and its knowledge of where these drugs were going. Do you know of any, can you think of any instance where a drug company could be liable under this act based on its knowing involvement in marketing drugs that it would know would end up used illegally?
Yes. Well, by its plain language, the Ddla imposes liability, and it's very careful with this language, participation in the illegal drug market with respect to an illegal drug. And on the first part of your question about the registration, the plaintiffs allege that by a registered manufacturer with a valid registration selling medications approved by the FDA to a validly registered distributor, that is the distribution of an illegal drug. But under the Ddla, an illegal drug is one that is distributed in violation of state law. And
bingo, isn't that it right there? Isn't that the pivotal point right there?
Well, respectfully, a legal drug is distributed in violation of state law. Under state law, Tennessee law, a manufacturer may lawfully distribute controlled substances if they're sold to a distributor who is also registered to receive them. And their view is that after that distributor sells the lawful medications to their customers, including pharmacies and entities across the country and including Tennessee, and the medications then are dispensed by pharmacies and ultimately are diverted into the illegal market, that transforms a sale from the manufacturer in the first instance into an illegal sale.
Mr. France, this is Justice Page. You would agree with me that most drugs can be both legal and illegal, depending on whether or not they're diverted, right? Even cocaine is a legal drug if it's prescribed and dispensed for nasal surgery, for example, correct?
Yes, yes. Drugs can, if they're, yes.
Let me ask you this. Can healthcare providers, pharmacists, dentists, physicians, et cetera, be charged or be liable, under the Ddla if they just either overprescribe or dispense the opioids improperly?
Well, this is the distinction between the lawful market for medications and illegal market. The Ddla was aimed at a separate distribution chain that's completely regulated.
Listen to my question. Okay. We have a pharmacist who's filling prescriptions when he or she knows that they're forgeries, or you have a physician who's prescribing 100 times more opioids than anyone else in the community. Can that person be liable under the Ddla?
It depends. If
the answer is yes in some circumstances, correct?
If they can, the answer has to be yes.
Yeah. And
yes, that pharmacist could be criminally liable.
Well, I'm not talking about criminally liable. I'm talking about being liable civilly under the Ddla.
Yes, but if the regulators in the lawful market determine that pharmacist or anybody in the lawful chain is exceeding, should be criminally charged, the Ddla has a provision that if there is a criminal conviction, then that is prima facie evidence of participation in the illegal market. But in the lawful market, there can be all forms of improper conduct, but that is governed by the robust criminal and regulatory enforcement regimes, which is different. That was not what the Ddla was intending to get at. It was intending to get at the clandestine sellers, those who facilitate the illicit market.
Counsel, this is Justice Kirby. Aren't you talking about the level of proof? Illegal conduct can take place right out in the open, as we have all seen. It does not have to be clandestine. So aren't you really talking about, since this is a motion to dismiss on the face of the complaint, aren't you talking about the level of proof as to your client's knowledge and responsibility?
No, respectfully, the complaint alleges various conduct in the legal market, activities by salespeople, sales that they allege exceed governmental regulations. There is a whole regime that deals with those types of conduct, and it can have serious criminal ramifications and penalties and the revocation of licenses.
This is Justice Bivens on Mr. Francis. Well, those provisions are not exclusive. There's not federal preemption of that. There can be liability under these acts if the state chooses to do so, correct?
Yes, those federal laws and the laws governing the lawful market do not have one key feature that the Ddla does, which is the limitation that the conduct be in the illegal market. And if you read the legislative findings, which are embedded in the Ddla in Section 103, you cannot read those and come to the conclusion that there was any, the legislature considered that this statute would govern a regime that is fully regulated. They were trying to fill a gap in a very narrow instance.
Well, let me ask you this question, and it's Justice Bivens again. There clearly is no express exemption for manufacturers in this statute, correct?
That is correct. And
other states have chosen to make that an exception.
I don't believe other states have exempted manufacturers. Other states have provided defenses if the distribution is authorized by law, but there's been no exemption. And if I could answer just Justice Lee's question, which I think answers yours as well, it can be a situation where a lawful distributor out the front door complies with the regulations, follows the lawful market, but out the back door sells to an illegal drug distributor. And that backdoor transaction could be participation in the illegal market, but that's not what's alleged here. See, I'm out of time.
Okay, thank you, Mr. Franz.
Thank you.
Mr. Wall?
You're on mute.
He's muted.
Oh.
You're muted.
You're muted, Mr. Wall.
Thank you.
There we go.
Sorry about that. I've done 100 Zoom meetings, and sometimes that just happens. I apologize.
We all do. That's no problem.
Michael Wall, on behalf of the appellees, the Court of Appeals ruled in our favor on both of the issues presented for review, and this court should affirm on both issues. I'd like to start by talking a little bit about the problem we're trying to address in this case. I think everyone's aware of how bad the opioid epidemic is, but in East Tennessee, it's really quite shocking. Tennessee overall has the second highest opioid prescription rate in the country, but in East Tennessee, the rates are through the roof. The city of Knoxville in 2017, for example, had a per capita opioid prescription rate of 6. The rate in the city of Cleveland was 8. That means 6 or 8 prescriptions, not just pills, but prescriptions for every man, woman, and child in the city in that year.
Well, Mr. Wall, respectfully, I think we all see the statistics, and certainly having grown up in Upper East Tennessee, I keep up with things up there, and I think Justice Lee's obviously in Knoxville. We all can see that the statistics show that the problem is very bad in Tennessee, and that East Tennessee is probably worse. But we're dealing with statutory construction here, so why don't you go ahead and get in with the statutory construction argument?
Absolutely. All of the plaintiffs in this case have standing. The baby dose standing is not questioned. With respect to the district attorneys, the place to start is Section 106 of the statute. Section 106 expressly gives a right of recovery to governmental entities that fund drug treatment programs or that otherwise expend money because of individual drug users. The DA's claim is ultimately rooted in Section 106 because the DAs are bringing it on behalf of their judicial districts and the local governments within those judicial districts that have spent money on drug treatment programs, extra law enforcement, caring for addicts, children, and other public services related to the prescription opioid problem.
Mr. Wall, this is Justice Clark, and they may be doing that, and Section 116 specifically authorizes them to represent the state or political subdivision in an action. but you need to talk to us about why represent in this case wouldn't default to its typical meaning in the law, which is be the attorneys bringing the suits on behalf of the municipalities or other subdivisions. That's very different from being plaintiffs themselves.
Yes, Section 1016 simply provides another way to get the local government's lawsuit into court. And it says that a prosecuting attorney, which everyone agrees is the district attorney, may represent the political subdivision. Tennessee.
What do you mean another way? The statutes before say how and say who. That just says a city doesn't have to hire and pay for a lawyer if it wants to. It can ask the DA to do the legal work. It's not another way of bringing a suit. It's another way to get representation in the suit.
Well, that's certainly the manufacturer's position, but the Tennessee has many rules and statutes that allow one party to represent another party in the sense of being a representative plaintiff, standing in the shoes of the other party and litigating on the other party's behalf.
But why would the legislature, if that's the case, why would not the legislature have specifically included the district attorneys in Section 106 instead of waiting till 10 sections later and talking about representation? They don't even talk about standing in that in 116.
I don't think that really cuts in either side's favor, because if you think about it, if 116 really is just a legal counsel provision, it would have been more natural to put that in 106 too, because 106 is about how the lawsuit's brought, what the remedies are, attorney's fees. So we may wonder why this was put in 116 either way. I don't think that it really favors either.
But to get back to your point and Justice Bivens' question, in many other places in the statutes, it will say, to look at 106A1, just for example, a parent, legal guardian, or their representative, or their agent. So the legislature knows how to say that, and it didn't say that anywhere in 106 about who brings the suit, who is the plaintiff.
Well, we might wish that it had spoken more clearly either way. I know there are plenty of lawsuits.
It's very clear. What you have to do is tell me why you think it's not.
Well, let me start here. This court has said on numerous occasions, and I can give the citations, that a district attorney is representing, uses the word represent, the state of Tennessee in a criminal case. That is the classic example of a district attorney not just being an everyday lawyer, but being an elected constitutional officer exercising complete discretion and control over the legal proceeding, because it's clear that the district attorney is the ultimate authority on a criminal prosecution. And even in
but the district attorney still remains the attorney. The state of Tennessee remains the party in a criminal case. And there's still a differentiation.
I don't think it's the nomenclature that's really important. What they're saying is that, we don't have, the DAs do not have the ability to control the litigation. That's what we're really talking about. Is a district attorney empowered to independently bring the Ddla lawsuit and then control it from there on out? And we're saying that the word represent is entirely consistent with that interpretation, but we can just start with the criminal cases because that's the classic example. Nobody reviews a district attorney's determination about charging someone for a drug crime or deciding which offense to charge. But even in the civil context, there are plenty of Tennessee statutes that allow a district attorney to litigate on behalf of the government, the state of Tennessee even, without asking anyone else's permission or answering to a higher authority. Those would be the nuisance statute, for example, the ouster statute.
Excuse me if I interrupt. This is Justice Page. Do any of those statutes you're referring to use the word represent? Don't they all use bring or initiate or words of that nature, which goes back to Justice Clark's point?
Well, they don't use the word represent, and I point out that they use different words. So there's no magic language that says this is when you're an attorney and this is when you're the party in control. Here are the statutes that use the word represent, and I think that the distinction is actually different. For instance, the quo warranto statute, 2935-109. The suit is brought by the Attorney General for the district or county when directed to do so by the General Assembly or by the governor or the Attorney General of the state concurring. And then there are several other statutes that allow a commissioner of a state agency to request or call upon the Attorney General and then the district attorney, and then the district attorney represents the state. So
but the district attorney does not become a plaintiff. the agency or the governor or the whoever entity of state government remains the plaintiff. The district attorney is the lawyer.
In those statutes, that's absolutely right, but it's not the word represent that dictates that conclusion. It's the fact that, for instance, in 43-6-106, it says that the district attorney represents the commissioner when called upon to do so. Or in the other statutes, when it says when he's requested by the commissioner to do so. And so those statutes are putting him or her in the position of a regular attorney, not because they use this magic language of represent, but because they say very explicitly that someone has to call upon the district attorney to file the lawsuit. So that makes it absolutely obvious that under those statutes, the district attorney is just an attorney.
Counsel, this is Justice Kirby. Part of your argument has been the practical ramifications about who gets to make the decisions. If you are representing a county, then the county actually makes the decisions and you are the lawyer, and said that the statute did not intend you to be plaintiff's counsel. How did that, I can understand why anybody would want control, but why does that make a difference to how we interpret these statutes? And you referred specifically to your standing being rooted in section 106, and I'd like you to elaborate on that and what language you're relying on.
So ultimately, the court is trying to figure out what did the General Assembly want to do, and we presume that the General Assembly did not want to do something useless or futile. So that's where some of these policy arguments come in. Under their alternative interpretation, the district attorney is just an option for regular plaintiff's counsel. If you think about, put yourself in the position of a district attorney, district attorneys do not have a lot of extra resources to go volunteer and be a regular plaintiff's lawyer in a city's civil suit. They don't have to, in this capacity as a representative plaintiff, go out and do the document discovery on the 12 million documents and the motion practice and so forth. They can let their outside.
What is the practical difference between a county asking you to bring this lawsuit and you making the decision to bring this lawsuit? You're talking about not having the manpower. How does that, for example, impact your ability to hire outside counsel to assist?
Well, if we're talking about the district attorney being his lawyer, here's what that would look like in this case. The district attorneys would have to go to 25 different county commissions and 88 different town and city board meetings and get those all to approve some formal resolution in a public meeting authorizing the lawsuit. Then they would have to call those.
Let me interrupt you 1 second. Did each of these county and cities listed on this complaint authorize the DAs to bring this action by resolution?
We do not have resolutions from the 113 bodies, but we absolutely have their support. And to make that clear in a few different ways.
Where is that found in the record? Where is the evidence of the support of all the listed persons found in this record, if it's not by resolution?
Well, the support we have is this. First of all, we've been litigating the case for 3 years. Not a single one of the 113 local governments has ever filed any kind of objection to the DAs doing this. Moreover,
were any of these governmental entities consulted, and did they approve the filing of this lawsuit before it was filed? Any of them?
I know that, I don't know personally because I was involved personally, but I know that the district attorneys and the plaintiff's lawyers here have absolutely been in communication with the local governments. But again, we have not gotten a formal resolution from all of them. I will say that the Tennessee Municipal League, and these cities and counties are in the Tennessee Municipal League, has filed an amicus brief in support of the district attorneys, saying that the cities and counties not only support that,
but that does not indicate the individual acquiescence of one of the cities. Someone earlier mentioned judicial districts. Is there a judicial district involved in this, one or more?
The district attorneys are bringing the suit on behalf of their judicial districts.
All right, so you're representing everybody today, so you'll have to answer their questions too. To whom in a judicial district do you go to get permission to file a lawsuit? It's an entity unlike cities and counties. So who is authorized to give permission for the DAs to represent them in a judicial district?
Well, I think that's actually a point in our favor because we're saying the statute doesn't require the district attorney to go get permission from all of the entities. So I don't know the answer.
But if we don't agree with that, who do you get permission from to be to name a judicial district or represent a judicial district?
Well, to the extent the judicial district's claim is for increased prosecutorial costs, that would relate to the district attorney's offices, and so they would be getting permission from themselves, I suppose. But I think this argument, this sounds more like if the statute were like the ones I mentioned earlier that said, you have to be called upon to do so or requested. And certainly if the Ddla said that, then we would have to show that the counties and cities requested the district attorneys to do this. That's how the legislature imposes that requirement, but it certainly hasn't done so in Section 116.
So you're saying that absent language that specifically says if they ask, a DEA has the right to bring any suit they want to, representing any group, any subdivision they want to, without any conversation with that subdivision about whether they want to be involved. They don't have to get permission, and then they're in complete control of the case. Is that how lawsuits work in Tennessee?
Well, it's how a nuisance lawsuit works. I mean, the district attorney brings a nuisance lawsuit, not on behalf of a county.
The nuisance claims in this case, though, have been dismissed, have they not? So those are not now before us.
Correct, but I'm giving an analogy to the Ddla, and there are many more. That's exactly how a nuisance lawsuit would work. A district attorney would not call up the governor and say, should I bring a nuisance action on behalf of the state of Tennessee? The same thing in an ouster case. The district attorney is not going to call up anyone else and say, am I allowed to do that? I could give the court a dozen examples of statutes that authorize a district attorney without any permission or consultation with another.
Counsel, this is Justice Kirby. If it turns out that we do not agree with you on this argument, what happens? Does that mandate dismissal of all of the DA's claims, or does it go back to the trial court for some other, for consideration of some other type of remedy?
Well, as my friend said, he's asking the court to dismiss as if these cases were brought without jurisdiction so that they're void. That's what they're asking the court to do. That will cause severe prejudice, not to the district attorneys, but to the local governments on whose behalf these suits were brought. At a bare minimum, it is going to cause extreme delay while the district attorneys try to collect those resolutions from the 113 entities. And that makes a big difference in a case like this, where one of the major defendants has gone bankrupt. Some of the others are threatening bankruptcy. 3 people a day are dying from overdose deaths. So delay is not just a minor concern.
So are you arguing that because there would be delay, we should ignore what we could believe the interpretation of the statute is?
Well,
are you saying we should make a different decision, not based on how we interpret the language, but based on the effect?
No, I'm just answering Justice Kirby's question about what the practical ramifications would be. And of course, in addition to just delay, naturally, if any of these local governments muster the resources to file their own suits, the first thing the manufacturers are going to say is they're time barred. I'm not saying they're going to win that argument, but obviously that's going to be a major challenge, and there will be others. So
Justice Bivens, if we're talking about practicalities, what's the practicality of settling this case if you were to ever settle at some point? Who has to give approval for settlement?
Well, if the district attorney is in charge of bringing the case and managing the litigation, and that's what they've been doing successfully in the parallel Staubus case that's trial ready, then yes, I agree the district attorney would settle on behalf of and for the benefit of the city. But that's no different from a shareholder derivative lawsuit where a shareholder brings a lawsuit in the right of the corporation and can
Where does this
that
statute authorize that, though? Other statutes do authorize that, and there's certain things that say when the state attorney general represents people in a case, they have to say grace over the agreement. But where does this statute say that?
Well, I would respectfully disagree with that. Some statutes say very explicitly when and in what circumstances the district attorney needs to get the permission. And many other statutes, many more statutes, the statute says nothing like that, and the district attorney does not get permission. Those will be, again, nuisance, ouster, civil forfeiture, anti-phishing statute, telemarketer statute, the list goes on and on. So I don't think that's the normal protocol whatsoever. This is the normal standard for a district attorney, not just in criminal cases, but in most civil contexts as well. And we don't think that there's any reason for the court to construe. If the court has the option of construing it broadly or narrowly, including 116, well, this is a remedial statute. And the court typically construes those remedial statutes broadly. There's no way to advance the policies behind the Ddla if people aren't bringing Ddla lawsuits. And so the more people who can independently initiate these lawsuits, the better. That's going to not just advance those interests, the General Assembly's interests, but also benefit the communities. This is for the benefit of the local governments. They're going to welcome whatever help they can get. Having multiple people sue to help local governments in these devastated communities is one of those good problems. We like to have that.
Mr. Wall, Justice Bivens, let me interrupt you, if you will. Why don't you turn to the application of the Ddla issue?
Yes, we've absolutely stated a claim in this case. The motion to dismiss standard is extremely high. They have to show that we cannot prevail under any set of facts. They cannot possibly do that. I mean, we've alleged that these companies have knowingly failed to maintain effective controls against diversion. That's their obligation under state and federal law. We've alleged that they knew about the incredible prescription volumes in East Tennessee, but kept flooding the market there anyhow. We allege that they've identified specific pill mills and doctors diverting the drugs, but kept supplying them, that they sent sales representatives to East Tennessee, even though they knew that the prescriptions were already far in excess of the medical need, and got them to prescribe more and more.
Mr. Wall, this is Justice Clark. Is there any case, federal or state, anywhere where a manufacturer under these uniform acts, and I realize they vary a little bit, has been held liable in the situation you are alleging?
I'm not aware of a Ddla case in which defendants like this were held.
There are none.
But then again, there are only a couple Ddla cases in the whole country, so it's hard to find any.
Are there any pharmacies where there has been liability absent what we were describing earlier as a backdoor transaction? The fact that a pharmacy orders and receives drugs from a manufacturer, both licensed and following their certifications, is not illegal. If they have a pharmacist who's selling out the back door, that pharmacist can be sued, and the pharmacy may be sued. But just on the receipt of the drugs under the certifications and licenses, has any pharmacist anywhere been held to be responsible?
No, but that's just nothing like this case. I mean, we're not suing them simply because they manufactured the drugs. I mean, we're suing them because they intentionally flooded and concentrated the drugs in an area of the country where they knew they were being diverted widely, and actually sent them to identified pill mills. I mean, that's a completely different scenario than like the Whittemore case, which I think you may be referring to, Justice Clark. So,
Mr. Wall, this is Justice Page. I have a question, make sure I understand the distribution chain here. Does this go from the manufacturer to the distributor and then to the pharmacy? Are there just three entities involved, or are there others?
That's the distribution chain. Then the pharmacy dispenses it to an individual. And then after that, individuals, of course, will pass it back and forth on the black market. But we're saying that.
Well, I know in your complaint, you've talked about diversion, and of course, diversion means many things in the law, but here it means taking legal drugs and using them for an illegal purpose. And it's alleged that you can actually get records and show where it's one allegation, and it says you can track these prescriptions or drugs down to the pill. Is that correct?
That's what we've alleged, yes, because they buy the data from data miners. And so it's not like they know nothing about what happens after the drugs leave their warehouse and go to the distributor. That's a complete misconception. They pay to know what happens to the drugs all the way down to the retail level. And so that's how we can allege that they know that these certain areas, particularly East Tennessee, have a super concentration of the addictive drugs.
And you're saying if, for example, in most places in the country, like Minnesota Tennessee has 22 times more of these opioids coming into the state than Minnesota does. And you're saying that when you try this case, you can actually look at records and show that in most states you get one opioid prescription for every 5 people, and here you're getting 6 for one person. Is that the kind of evidence you're going to use to prove your case?
Absolutely. I mean, we have allegations saying that Tennessee's rate is much higher, many times higher than other states, but there's going to be lots more evidence than that. Employees high-fiving each other about supplying the pill mill that they name in East Tennessee. Isn't that great?
And your third amended complaint's over 100 pages long. You have all these allegations in there. That's correct, isn't it?
That's absolutely right. I mean, they can hardly argue that this is a thin complaint or we haven't pled it in detail. I mean, it's there, in spades as far as the details. And these kind of activities are so far beyond what a responsible pharmaceutical company does, just selling drugs to a distributor. There's just no comparison. I mean, when you're dealing with not a regular drug, this is a Schedule II narcotic, just like cocaine. If you know a place or a particular pharmacy is providing those drugs at a rate that could not possibly be explained by legitimate medical use, there's a duty under law to stop doing that. And these companies knew it and continued to do it. That's what we've alleged.
Mr. Wall, there are at least 2 cases, Ashley County versus Pfizer and Cooper versus Purdue Frederick Company, which have held that the DDLA does not apply to pharmaceutical companies. What makes your case different than those 2 cases, which held differently than what you're asking us to hold today?
Well, I would disagree slightly, Justice Lee. In the Cooper case, I would call that absolutely dicta. The actual decision before the court was a procedural question about whether the case was time barred and so forth. The court made a statement that this only applies to drug dealers, not pharmaceutical companies. But if we look at what actually happened in that case, the plaintiff got an OxyContin prescription through perfectly legal, legitimate channels, with a valid prescription and so forth, and was just saying the drug is bad. So the court very naturally said, well, that's not a drug distributed in violation of state law, so that there's no Drug Dealer Liability Act claim here. Here we're saying the drugs become illegal 2 different ways. The first way is we're saying the manufacturers actually are distributing illegal drugs because they're failing to comply with that registration law that says they have to have effective controls against diversion. So they lost their special privilege to do this legally. And then secondly, of course, once it gets to the point past the pharmacy where people are passing them around with no prescriptions, that's illegal. And the Ddla says that we can hold these defendants liable for that if they committed acts intended to facilitate that distribution on behalf of the third parties.
So there doesn't appear to be a case in the country that has held that the DDLA applies in this situation. Is it your position that your complaint is very different and makes different allegations or stronger allegations than these other cases where the plaintiffs have lost?
Yes, I mean, the allegations are extreme. In those other cases, you would have a weird situation like in the Shopko case where the state law actually allowed someone's agent to go pick up the prescription. So again, the court's saying, well, state law allowed them to do this. There is no illegal drug distribution here, so there's no DDLA claim. Our allegations are very different and they're egregious, the things that we're alleging. So yes, I will say though, that one case, though, the Whittemore case from California, did not hold the pharmacy liable because the one rogue pharmacist was selling it out the back door. So it said the pharmacy itself didn't have knowledge, but it did say that the DDLA clearly applies to prescription painkillers, in that case, OxyContin. That's the same kind of drug we're talking about here. So I think it's very clear from that case, and no other court disagrees with this, that prescription painkillers can be illegal drugs under the DDLA.
However, aren't we still required to look at Section 104.1, which defines illegal drug, and I think you referred to this earlier, as a drug, the distribution of which is a violation of state law. It is not a violation of state law for a manufacturer to sell at the request of a distributor or a pharmacy directly, as long as all of their certification and requirements are met. It may become an illegal drug later down the chain by the misuse of or the criminal acts of someone, but the actions they take do not fit the definition of illegal drug, do they?
No, I would strongly disagree with that, because it's not the case that these drugs just become illegal past the point of the pharmacy when people start handing them around. Our allegation, and this is supported by the registration law in Tennessee, is that these companies may not distribute illegal drugs unless they comply with the entire regulatory regime. And specifically, that means having effective controls against diversion, not just any controls against diversion or some controls written down on a piece of paper, but effective controls against diversion. And so that's where their obligation to understand what's happening with their drugs and to do something about it comes into play. And this also exists on the criminal level.
By analogy, would you say that the same thing can be true of alcohol, which is a drug? So somebody, a brewing company manufactures alcohol and it sells it to a local grocery store. There is knowledge that people misuse alcohol once they get it. The same thing could even be true of mouthwash that has alcohol in it. There is some knowledge that some people will drink a lot of alcoholic mouthwash because of their addiction. Does that mean that the manufacturers of those drugs, if you will, that can be used inappropriately should be responsible for everything that happens down the chain, even though they're being manufactured for a different purpose?
No, we're not asking the court to rule anything that broadly. Here's a good analogy in the alcohol context. It would be like the distiller not just selling the bottles to the distributor or the liquor store, but sending people in vans to go pick up kids at college who are underage and take them to the liquor store that everyone knows will sell to the underage people. That is the kind of allegation we're making about these companies. It is completely beyond the normal framework for selling the products that they're selling. So before my time runs out, I'd like to just go back, if I may, to something very quickly on standing. Of course, we take the position that the word represent is not supposed to be magical language, but that when it comes to district attorneys, they are already the people in Tennessee who are in charge of every other aspect of dealing with illegal drugs, bringing the drug prosecutions, seizing in forfeiture proceedings the drug assets, abating the drug house as a nuisance. It would be extremely odd for the General Assembly to refer to these people, the top officials and the people with the most expertise on illegal drugs in Tennessee in the Ddla, and then give them a bit part or give them a role that doesn't make any difference. We think that is just impossible to square with the goals of the Ddla, the fact that it's said to be meant to be a complement to the criminal justice system, and then the normal role of a district attorney, both in criminal cases and a variety of other civil cases. If the court were to agree with the manufacturers on the standing issue, we think this is going to cause a lot of prejudice to the local governments in Tennessee, especially East Tennessee. And that would be a shame because nobody else is out there litigating on behalf of the local governments or trying to put them forward in the settlement negotiations. And so I don't think it's inappropriate for the court to understand the real world impact of what they're asking it to do. Thank you.
Thank you, Mr. Wall. All right. Mr. Franz? You're muted, Mr. Franz.
Just a few points. First, with respect to standing, what we've just heard here is that their interpretation of the kind of takes the word represent beyond all recognition. They're not claiming to represent these entities as an agent. They're basically saying they're the principal. They totally control the lawsuit. And that is totally counter to what the word represent means, even when we're talking about representing parties as opposed to representing them as counsel. And they've said that they could even, if I've heard correctly, could even settle the case, potentially even if these entities they purport to represent didn't want to settle or didn't agree with the settlement. And this all runs headlong into the autonomy of government entities. The Attorney General, the legislature has given the Attorney General the authority to, exclusive authority to represent the state in civil matters in the courts. And in their interpretation of the Ddla, they can represent the state, not just the political subdivisions, without the state's consent and bring a lawsuit, even if the state doesn't want them to. And with the political subdivisions, their interpretation of represent kind of runs roughshod of a local government's autonomy to manage its own affairs. And if you know long-standing precedent holds that when you're interpreting a statute, you should seek to harmonize potentially conflicting interpretations. The only interpretation of the Ddla standing that harmonizes and avoids all of the issues about intruding on the government's rights is our interpretation, which is that the Section 116 means that they can represent the political subdivisions or states as parties. They may, they don't have to. The remedial purpose, the court below and plaintiffs argue that, well, represent can mean as counsel, or it can mean as as standing in the shoes of a party, and you should break the tie because more enforcers is better. But the legislature didn't say anybody and everyone can bring a Ddla action. They defined the 5 categories of plaintiffs, and district attorneys weren't on the list. And so the court should be very careful. The remedial purpose shouldn't be used to expand a court's subject matter jurisdiction, particularly when the legislature has determined who should be able to sue. And I mean, let's be frank here. There isn't a shortage of lawyers in the opioid litigation ready and willing, plaintiffs' lawyers ready and willing to represent political subdivisions. There's some 3,000 lawsuits pending in federal and state courts across the country by local government, states, and others.
This is Justice Page. Let's turn to the other issue before the court just a moment. And I want to give you a chance to address something that's of concern to me. We are here on a 12026, grant of a 12026 motion. Of course, you know what the standard is to that. And the Court of Appeals, in their opinion, said something, and it's about 5 paragraphs from the end of the opinion, but I just want to bring this up and let you respond to it. They said, drug manufacturers cannot, as is alleged here, knowingly seek out suspect doctors and pharmacies, oversupply them with opioids for the purpose of diversion, benefit from the process, and then cynically invoke their status as otherwise lawful companies to avoid civil liability. How do you respond to what the Court of Appeals said in their conclusion?
Well, it suggests that wrongly suggests that the lawful participants in the lawful market are seeking some kind of immunity or exemption. They're certainly not. In the lawful market, there are laws that govern every type of allegation that plaintiffs have alleged in their complaint. It's a long complaint, but the complaint alleges conduct in the improper practices in the lawful market, not participation in the illegal market. And so if a manufacturer or distributor sells a suspiciously large order of medications and they don't report it as required by the Federal Controlled Substances Act, or a sales representative acts improperly on a what would normally be a routine lawful sales run, there are laws, criminal laws and regulatory laws that address those matters. And that's just not what the Ddla was aimed at. The Ddla was aimed at participation in the illegal market, and the statute references. The experts have studied that there is a parallel separate market that has many participants, and the problem they were trying to address was giving the plaintiffs the ability to sue. They would have never adopted, the legislature would never have adopted market liability, which it claimed was destructive of legitimate markets, if it had ever intended the statute to apply in the lawful distribution chain.
You're saying this all turns on what Justice Clark pointed out earlier, the definition in 2938-104A, that illegal drug means a drug, the distribution of which is a violation of state law, and you're saying this is not.
Well, yes, I mean, in part, but it relies on the definition, of whether this is participation in the illegal market. And the statute takes pains to make that limitation. Their reading would read out the participation in the illegal market limitation that's throughout the statute. And there's reference to the other cases in the country. The reason that courts have not applied this statute, they have different fact patterns, but the common thread is just the common sense that this statute was never intended to apply to the lawful market, which is one of the most heavily regulated in the country. There was no gap to fill for conduct in the lawful market.
Mr. Franz, do the drug companies have any explanation for why Tennessee would have the second highest statewide opioid prescription rate in the nation? Campbell County would have the third highest county opioid prescription rate in the nation. What's unique about Tennessee or Campbell County, which puts them at the top level of opioid prescriptions, but for the fact that these pills are being used illegally?
Well, we have to consider the distribution chains here. The manufacturers sell lawful medications to distributors, and distributors on a national level, and the distributors are then have their own customers who distribute the medications on a national level. Now, if the distributors are getting a disproportionate or suspicious orders to Tennessee, then there are ample regulations and laws that require them to report those orders.
And if your client knows, the proof says, the complaint says, knows what is going on and continues to pump the drugs into that market, how is that not covered under the Ddla?
This goes back to the example of the alcohol manufacturers. If an alcohol manufacturer knows at some point that underage minors are drinking whiskey and that they can injure someone or injure themselves, are those manufacturers going to be liable for the distribution of an unlawful product? And you can go on and on. And again, the manufacturers distribute the medications to distributors, and manufacturers have requirements that if there are suspicious orders that they need to report those to the DEA, and there's a whole regime that covers that. But the Ddla was addressing a totally different issue.
Mr. Franz, this is Justice Clark. What do you understand the levels of proof to be in a case like this? Do plaintiffs have to prove specifically what your company knew, or are they pursuing essentially a market share theory where they don't really, if they can just prove that it's prevalent enough that everybody should have known, they don't have to prove what you knew, that they can just look at market share of the number of people they sued and get money from all of them?
Well, yes, and that's the market share, the Ddla adopted market share liability, which makes no sense in the legal market. In an illegal market, you might want to say, okay, we don't know who sold the drugs that injured the person, but we can go after and tag all these other participants in that market, even if they don't have any connection with that particular person who used the drugs, because everybody's engaged in illegal conduct. And when you apply that to the lawful market, it doesn't make sense, because the people who are supposedly facilitating the improper conduct can be the truck drivers who are delivering the medications, the guards who are protecting the manufacturing plant. It's a limitless and they're view no limiting principle.
Thank you, Mr. Franz. I know you're answering the question. I wanted to let you finish that, but I think that's good. And by the way, your time is up.
Thank you.
Thanks to both of you very much. We very much appreciate you being with us here today for this oral argument. We have one more case on our docket that we will take up at 11:30 Eastern Time, 10:30 Central. So until that time, we will stand in recess.
This honorable court is now in recess until 11:30 a.m.
Thank you.